Good evening and welcome to Law Talk, the show that brings the news, the law, and current events into your home each month. Tonight, I'm James Barrett, and with Mark Malachowski, we're going to be exploring some areas of the current events as they relate to the law. Mark, what are we covering tonight?
Tonight, we interrupt this regularly scheduled broadcast to make an official announcement.
And what kind of announcement would that be?
Comrades, greetings from our illustrious chairman. I am proud to announce a great victory of the people's social justice. Our illustrious chairman, who casts no shadow as he leads us down the march on the path of the shining light to social justice, has relieved you, his children, of the painful burden of having your vote count in elections. And as in his benevolence, decided that only worthy party candidates will be elected and that these candidates who are traitors to the shining path of social justice will be denounced. Denounce your neighbor immediately to your local committee if you suspect they may be a traitor to the shining path of the march to social justice. So they may be sent to re-education camps, made to wear paper hats, paraded through the streets, to be spat upon in public, and then, of course, shot. We are proud of the 90 million counter-revolutions we have re-educated and shot for the cause of social justice, because therein lays our power: denunciation, re-education camps, humiliation, death. Do not hesitate for 1 second to denounce your neighbor, because in that second, your neighbor may denounce you first. All hail our illustrious leader who casts no shadow while leading us down the shining path on the march to social justice. You want to hear a good one?
And Mark, after all of that, I need a good one to get out of that one. Go ahead, tell me what's up.
3 political presidents are in a re-education camp comparing the reasons for being incarcerated. The first says, I'm in for being a supporter of the capitalist pig, Ted Stevens. The second replied, that's funny. I'm here for attacking the capitalist pig, Ted Stevens. The two turned and asked the third, what are you in for? Shaking his head. You know what he said?
That I'm here because I am Ted Stevens.
That's right.
So are we covering Ted Stevens tonight?
We're going to cover Ted Stevens tonight.
Well, tell me about Ted Stevens.
Well, Ted Stevens was a senator in Alaska for 8 terms, which is a long time.
Well, that's a long time in the U.S. Senate. That's almost 50 years.
And some people are claiming that he was framed and accused of taking $250,000 in bribes from oil company executives, when in fact this was based on false evidence.
Well, I understand Ted Stevens is the senator that actually was integral part of bringing about the state of Alaska as a state in the United States. So he goes back quite a ways, and his strength in Alaska has been well regarded by Alaskans. So why would they come after him for some kind of bribery charge?
Well, that's hard to say, but Ted Stevens was a popular senator because he helped secure some remuneration for Alaskans from oil revenues.
And you're talking about where annually the oil companies issue checks to every native Alaskan as a remuneration for the fact that they're allowed to drill oil in Alaska.
Right, and Ted Stevens helped out on that, so that made him very popular, among other things.
I understand that he also brought a lot of money back to Alaska, including the infamous bridge to nowhere. But is that why that they wanted to take him down, or what real reason was?
Well, we don't really know, but what happened in his apparent bribery scandal trial, an FBI agent turned around and blew the whistle on the Justice Department.
What do you mean they blew the whistle on Justice? What was Justice doing?
Well, what this FBI agent said was that they were manufacturing evidence against Stevens.
Well, wait a minute. Manufacturing evidence is one thing, but the fact, is there evidence that the prosecutors had that would have actually was exculpatory evidence that you can use to show that the person's innocent? I understand that came up as well. Right,
and his allegation was there was improprieties in the investigations, what was presented, and that also, I think that, I don't know if the FBI agent is participle to that, but it came out at some point through somewhere that evidence that could have shown that Stevens was evidence was concealed by the prosecution.
You mean that Stevens was innocent?
Right.
Yeah, okay, so the FBI agent brought this up, but I also understand that Judge Sullivan, the judge that presided over this, he could tell, in fact, he had warned the prosecutors to release all evidence that could be exculpatory to Ted Stevens' attorneys, and they refused to do so.
And my understanding is that even those prosecutors were held in contempt in some cases, but the judge didn't say the magic words.
And what are the magic words?
He was supposed to say, you must follow the law and provide the exculpatory evidence. And since he didn't say those exact words, it's hard to go back to the prosecutors and really do any serious sanctions.
Yeah, I understand you got to say that on the record. If you don't say that on the record, there's no way that you can actually legally hold prosecutors in contempt of court under that procedure. Is that correct?
That's correct. And it's a lot like a lawyer making an objection. You have to make a timely objection, or you lose your right to object to that, whatever that evidence is coming in.
Okay,
and
so
in this case, the prosecution was not revealing what they should have revealed, and the judge didn't quite frame his wording correctly, so he could go back and sanction them in a harsh way.
Well, I understand that Ted Stevens was convicted of these charges, but the judge had, because of his knowledge that he believed the prosecutors were acting in prosecutorial misconduct, he delayed sentencing until this FBI informant came out. Isn't that correct?
Well, there's some question about exactly what the whistleblower said, because it's a huge report. I believe it's 500 pages, hasn't yet been released. So actually, a lot of this is speculation. You know, the FBI agent said that it was improperly investigated, said that evidence was withheld. So it's really unclear until we see that 500-page report. It's not available now, but gleaning from what the judge said about it, what we do know, there was prosecutorial misconduct, and evidence that could have proved that Stephen was innocent was intentionally withheld.
Okay, I understand now. I will tell you, Attorney General Holder, who actually used to work in an internal affairs area of the Department of Justice early on, actually worked with Judge Sullivan when they were both in the same department. So actually, Attorney General Holder came back and he wanted to strike the prosecution completely based on the prosecutorial misconduct.
Well, to his credit, when Holder looked at this, he had misgivings about going forward on the prosecution.
And because of those misgivings, he felt that the prosecution should be terminated, that they weren't going to push for the sentencing, that in fact all charges would be dismissed.
Right, and so Holder did, the correct thing in these questions. Now, like I said, we don't really know what happened because we haven't seen the report. It's not public. I don't know when it will be released.
Well, probably
ever.
Yeah.
But apparently it's quite a lengthy report. 500 pages is a lot of pages for investigation.
They're probably waiting for a time certain when everything cools down.
Yeah.
But there's a problem with this. This prosecution was going on at a time where in the Senate, the U.S. Senate, Stevens, if he had won, would have created 59 Democratic senators, as opposed to when his opposition won, who was a Democrat, which made the 60th Senate, giving it effectively foolproof veto.
A filibuster.
Filibuster proof on any law.
And so this would be considered a bloodless coup.
Yeah, in fact, because having 60 members in the Senate of one party, and in this case the Democrats, having a House that was all Democratic, and having a president the Democratic, it seemed to be like the perfect storm. And I think as we look at what really happened, which we're going to cover in our next segment, led to, legislation that was contrary to the general public.
Well, it is incredibly disturbing when you have the Justice Department involved in something that influenced the election. And this definitely influenced the election. So this election was definitely swayed by this prosecution. The prosecution was definitely flawed. And so this is a huge problem if the Justice Department of the United States of America is actually influencing Senate elections.
Yeah, well, see, the interesting part was even Stevens almost won the election. He lost by a very narrow margin.
Even though he was under this...
Even though he was under the prosecution, under, this indictment and the sentencing and the whole deal. Well, there's one last sad factor to this entire story.
There's also some issues that, Alaska has some long-term political infighting. Senator, I guess it's Begich, Mark Begich, who was the beneficiary of this thing. His dad had been a senator and a congressman. So there's a lot of political power plays in Alaska itself. Whether they were able to influence the federal prosecution or not, we don't know. But it is deeply disturbing that the filibuster-proof Senate, basically the takeover of the whole U.S. government, hinges on
Stevens.
Hinges on basically the Justice Department framing an innocent senator.
Well, to wrap this up, the fact is Ted Stevens died in a plane crash.
Right.
He never even saw the full waiver of, I mean, his reinstatement as a person that shouldn't have been prosecuted. And that kind of leads us in. Because of that 60-vote margin, doesn't that lead us into our next subject under Constitutional Corner?
Well, SCOTUS, the Supreme Court of the United States, decided to take Nancy Pelosi up on her bet.
And what bet was that?
And her dare, I should say. And, you know, when they said, look, you got to pass this without reading it. We've got the majority, so we don't really care what anybody says. We're rolling this through. And they actually put Obamacare through on kind of a budgetary. So a lot of people would argue the actual process of passing the bill, because they didn't have enough votes once the senator from Massachusetts got elected. So they had to put it through in kind of a budgetary, what they call the nuclear option. So a lot of people would argue that wasn't constitutionally valid at all, even the process.
Well, as we go back to our prior, the 60th vote that
Right.
came in was the Democratic Center that won over Stevens. And as we look at the Affordable Care Act, that's
Right.
the Obamacare, we realize that Obamacare now has been challenged in many districts. We've talked about this before.
And when people raise those objections to Nancy Pelosi, who was pretty much pushed this thing through, she said, are you kidding? Are you kidding? Well, it turns out nobody was kidding. I guess we have 26 states. There are attorney generals. Went through district courts. And I think in general, it was 3-2. I mean,
3-2.
Most of the rulings were in favor of Obamacare, but there was a couple of rulings.
And those
hard
rulings,
against, yeah.
And so what we're talking about tonight is the Supreme Court decided that, and which is interesting, the reason it got to the Supreme Court is because the Obama administration did not file their appeal at the lower district court in a timely manner, which automatically allowed it to move forward to the Supreme Court, and their appeal could have held it at district court until potentially after the 2012 election. But because they missed their filing deadlines, this moved to the Supreme Court. And that's where we have now. And I understand the U.S. Supreme Court is going to be addressing this in the 2012 session. And I believe in March or April, there's going to be 5.5 hours of argument allowed.
No, there's going to be 5.5 days, 2 hours per day. 2 days at 5.5 hours.
Right.
So you're going to have 10, 11 hours.
For and against.
And that's huge, because usually a Supreme Court, a SCOTUS hearing is a half hour.
Right.
You know, I mean, it's incredibly short because they're briefed. The justices have read it. They're following the cases as they go along. And so to have, 5.5 days, these 5.5 hours is just huge. It's a huge, huge case. They're going to spend a lot of time looking at it.
Okay, well, I like to just to give everybody an idea what we're talking about in this. There's actually 4 main subjects that are being addressed in this. The first subject is whether or not this falls under the Anti-Injunction Act. And under this act, it states that